Good morning, or good afternoon. My bad. Good morning. There, I do it again. Good afternoon, everybody. This is Kelly with Career Force. Welcome to this afternoon's Employer Lunch and Learn session. I would just like to draw your attention to the screen and that we are with Corey Walton and David. I'm going to probably butcher your last name, Scavolt, with Minnesota Department of Labor and Industry and the Department. I'll let them introduce themselves because I'm just going to make a big old mess of that. Anyhow, Labor and Industry and Department of Labor are with us today to talk about a bunch of interesting details and facts with state leave laws and the Family First Coronavirus Paid Sick Leave provisions. Up on the screen is our layout for the St. Cloud Area Career Week. We do have a bunch of virtual career fairs happening this week. Also wanted to make you aware of the Employer Lunch and Learn sessions that will be available all week this week. Today we're in webinar 1 and the agenda is up in front. It's also in your Q&A box. After today's session, I will be sending out the web link for webinar 2. And then on Wednesday after the webinar, I will be sending out the web link for webinar 3. If you have questions that you would like to ask of David or Corey, please go ahead and put them in the Q&A box and I will have Corey and David answer those questions. If you're new to Teams, you'll notice that there are thumb up signs inside that Q&A box. If there's a question there that you've seen typed that you would like to have answered and you see somebody else has already asked that, go ahead and put the thumbs up box. That just means that there's more emphasis on that question and you definitely would like that answered. We'll definitely make sure that we put every effort into that. We only have an hour for today's session, so we want to try to get to everybody's questions as much as we can. So with that being said, we are recording today's session, and so I will go ahead and send out David and Corey, will you guys be able to give me copies of your PowerPoint slides?
Absolutely.
Okay, so we'll get a copy of the PowerPoint slides and a copy of today's video recording and get that out to you guys after today's session so that you'll have a copy of everything that was presented today. With that being said, we're going to go ahead and get started. David's going to go first, and David's all ready to go, so we will go ahead and let him share his screen and we'll go from there.
Okay. Kelly, I don't think mine's coming up, but maybe that's because you're still sharing. Okay.
No, I just stopped.
Okay. Okay, here we go. All right. Is that showing up?
Yeah.
Excellent. Okay. Yeah, thank you so much, Kelly. Yeah, my name is Dave Scavolt and working with the Minnesota Department of Labor and Industry in the Labor Standards Division. So today, I think we have 3 consecutive presentations, today, tomorrow, Thursday. And today, my part of it is going to be pretty brief. And it's kind of a variety of different issues that are related to things that we're seeing, hearing, things that are coming up related to coronavirus, everything that's gone on over the last 6 months, et cetera. And you know, the concerns that we're hearing most from both workers and from employers. And then additionally, with the leave provisions that we're going to be talking about federally, I did put a little emphasis on a few slides on some of the state leave provisions. So let's jump into it. Got to get that to move. There we go. All right. So these are the laws that labor standards on a state level enforces. And so the Minnesota Fair Labor Standards Act is kind of the bedrock one, and that's the minimum wage and overtime law. And you'll see some of those other laws that we enforce. One of the things that Corey and I always bring up when we present together, and one of the reasons we really like presenting together is, you know, that it can be difficult for employers or the public or for employees to kind of understand how the different labor laws intertwine together. And you know, so as an employer, you're trying to navigate, you know, state, federal, and then now we have local local employment laws of different kinds, and you know, as an example, the minimum wages in the cities of St. Paul and Minneapolis. There are other types of local, you know, labor laws as well. There's a variety of them. But so as an employer, what you know you're always wanting to do is to make sure that you're looking at what is the law that's the most protective of the worker, and that's kind of the one that you want to make sure that you're in compliance with. And once you're in compliance with that, then you're going to be in compliance with any other set of laws. So as an example, an employer in Minneapolis that's compliant with the Minneapolis minimum wage. So let's say that employer, I don't know exactly what it is right at this point, but there's different, you know, there's different levels for different size employers. But let's say it's, you know, $11 an hour or $11.50, and that employer is paying that, then they know they're going to be in compliance with the state minimum wage, which is lower, and also the federal minimum wage. So, so sick and safe time, yeah, those cities do, and as well as Duluth now has sick and safe time ordinances. You know, there isn't anything like that around the St. Cloud area, but there is a state law that does talk about this in a certain way. It doesn't mandate that employers pay sick or safe time, so that's still, you know, up to the employer to make that decision. What the state law does say is that if the employer does offer sick time, that it needs to allow the employee to use that sick time to care for certain family members. So not just their self. So if the employee has a spouse who's ill or a child who's ill, that the employee would be able to use that sick time that's provided by the to care for that employee in the same way, for the same needs that they would have to care for themselves if they were similarly sick. So again, parental leave, this isn't really that relevant to coronavirus, but the leave that's offered under state law, and it's similar to the FMLA law in that it's 12 weeks of unpaid leave. What the main difference here is, and I'll just highlight what the difference with FMLA. So FMLA and the state parental leave is typically going to run concurrently to each other if that employer and that employee is kind of eligible for both. Where you see the main difference, or one of the most significant differences with FMLA and the state parental leave is the threshold of the amount of employees. So whereas FMLA is required for employers that have at least 50 employees within a 75-mile radius. So that's the designation for at what point FMLA is required. And Corey, you know, is the expert on this, since the FMLA is the federal law. So correct me if I'm wrong, Corey. But and then on a state level, what you see is that the requirement of the parental leave law is that the employer has at least 21 employees at one location. So that's it's a different type of measurement. It's, you know, I don't know how, you know, the legislature came up with that type of measurement, but they did. And so you could have an employer, maybe a gas station that has 10 locations with, 12 employees. They're not going to be required under the parental leave law. And you could have, one location with 25 employees, and that employer would be required to follow the parental leave law. So it's kind of a different type of thing. In that gas station example, that employer might likely to be required to follow FMLA because they're going to have more than those 50 employees, and likely it's that less than 75-mile radius. So you can see the parental leave also requires for the employee to be eligible, they have to have worked at least half of what the employer considers a full-time schedule for 12 months. And those 12 months don't need to have necessarily been the last consecutive set of 12 months. All right, so this is one jumping back into issues that are kind of more relevant for right now. We've seen a lot of people, whether it's a temporary or a permanent loss of employment. So there's a lot of questions coming up about last paychecks when it comes to wage and hour law. Minnesota has this unique law that allows employees that are terminated, that are let go by the employer, when the employer makes the decision to end that employment relationship, that employee can request the last paycheck, and the employer would need to pay that within 24 hours of a written demand. So it's not a verbal, it's not, you give me that paycheck tomorrow. It's the employee does need to give a written request or a written demand. And once that written request or demand is put in, then that 24-hour clock starts. Of course, after the person's terminated, right? If the person does not put in that written demand or request, or if they leave on their own, they quit, then it's just it's going to be that next regularly scheduled payday that they would be due all their final wages. There are a few exceptions to that. One of them is that if the payday was within 5 days of the last day of their work, then the employer could extend that up for up to 20 days. And so final wages is probably the #1 type of complaint that we receive from employees or workers to our division, where somebody's calling us and saying, I left my job for X and X reason, and I wasn't paid everything I was owed, whether it was partial not paid or fully not paid. It could be that they had deductions that were taken from them at some point that were supposed to be returned and they were not returned, things like that. So we have what's called a wage claim process, and we try to more or less act as a mediator, try to get that settled without going through the full complaint process, investigation process, but more or less contacting the employer, letting them know what the law is, and trying to bring the two groups together and get that person paid if they're owed any money, and everybody move along to the next part of their life. All right, so here's another one that again has come up a lot, and it's similar with employees changing jobs and moving on in their life. And so the question is, if an employee leaves their job, are they due to be paid unused sick, vacation, or PTO? And the answer is really going to come down to what is the employer's policy on that. So there isn't any state law that requires it. What is the employer's policy? Possibly there's a collective bargaining agreement involved or other type of personal contract, but there's nothing in state law that requires that to be paid out. But the employee potentially could go to a small claims court or through a union grievance process if they felt like that was supposed to be paid out, and they had some policy or some other type of documentation to back that up, that the employer had agreed to pay that out. All right, so employee notice. This is part of that Wage Theft Prevention Act that passed in 2019's state legislature. And so we may be familiar with this. The reason I'm bringing it up now is, again, with a lot of the changes that are going on for employers and changes related to pay, vacation, a lot of adjustments are being made. So this is a reminder that if an employer decides to make one of those adjustments, let's say they're changing a wage rate, they do need to provide that information to the employee in writing before that change is enacted. So let's say that I am getting a pay rate change starting October 1st. It would be a good idea for the employer to right now send me an email or some type of paper. Maybe they're working at home. They might send me a letter that informs me that my pay rate is going to be changing starting October 1st. And then the employer wants to make sure they're keeping a copy of that communication because it's considered part of the employee notice, a living document more or less of that, documenting that pay rate change. So this I kind of already noted. I'll pass this over. There was an expansion of the workers' compensation law. This was in the spring, and this is outside of my area, but it's covered by our department. So I want to note it here, and that is that there's expansion of, again, the workers' comp, and it relates to that there's now a presumption that certain workers who contract COVID-19, that there's the presumption that they've contracted it through the workplace. And you can see the list of those type of employees there that is mostly related to healthcare, childcare workers that are assisting healthcare workers, and also police, paramedics, and emergency responders. OSHA, again, this has been the part of our department that has probably received the most, that has become the most busy related to everything that's going on. They're in charge of the preparedness plans and also making sure, of course, that workplaces are safe for workers and for employers. So I'm noting this here to say there's kind of two parts to OSHA. One is OSHA compliance, that first bullet point, and that's where workers typically will call if they have a complaint. And those are the people that come out and do workplace inspections and potentially will assess fines or penalties if they find violations. Workplace safety consultation is different. They work with employers to kind of the beforehand. Let's prevent mistakes from happening. Let's fix potential safety violations. And if they come out, they are to assist the employers. They don't assess fines or penalties. In fact, sometimes they have grant money available to help employers. They are currently helping employers with the preparedness plans and things like that. So that's kind of the more of the for employers to start. A lot of that workplace safety consultation side of OSHA is a good place to start if you want to contact OSHA. And then finally, this is my last slide, and I'll pass to Corey. We've had a lot of questions. Again, this is not an issue that our division necessarily is in charge of or oversees, but this issue of reasonable accommodations. So a lot of people have been making assertions that they need reasonable accommodations related to coronavirus related issues. And it may be that somebody has a certain health condition that makes them more vulnerable to be in certain environments. And so this is related to the Minnesota Human Rights Act, and also on federally, the Americans with Disabilities Act, that provides that employers give reasonable accommodations to employees that potentially have a disability or certain health conditions. So the Department of Human Rights is the spot to contact for those questions. And let's see here, that's the end of my presentation. Pass to Corey. Oh, excuse me, don't do that. Let's see.
Okay, as soon as you can see my PowerPoint, let me know, please, David or Kelly.
Yeah, I have to stop sharing. But...
Yeah, it's not coming up just yet, Corey.
Okay, I'm sure it's on its way.
Here we go. Okay, give it a shot now, Corey.
Okay. Can you see it yet?
Nope.
Okay, let's try this.
Bear with us a minute, everyone. Do we have coronavirus? There, we got it.
All right.
Thanks,
I think I started sharing before Dave ended sharing. So lesson learned. You got to wait till that person stops sharing. Okay. Good afternoon, everyone. Again, my name is Corey Waltman with the U.S. Department of Labor Wage and Hour Division. And just going to shift gears a little bit and talk about a different topic. Dave kind of gave me a good segue to this topic, because it is leave laws. It's paid sick leave laws. And it's required paid sick leave law. So this is not an optional thing for employers. This is something an employer has to provide eligible employees. But just one thing I want to say about this Families First Coronavirus Response Act. So it's still relatively new. April 1st, it became effective, and it has an expiration date. So on December 31st, New Year's Eve, this is set to expire. So we're in September now, so we got a couple of months left. Now, we haven't been told it's going to be extended or anything like that, but I mean, who knows about these things sometimes. So we'll keep our ears to the ground, and if it does get extended, or there's word it might get extended, we'll make sure we let everybody know. But for now, it's December 31st is the expiration date. Okay, so by the way, Kelly or David, if my slides don't advance, also tell me that, because you guys know how technically challenged I am sometimes. But I'm assuming everybody can see what I can see. So this is my roadmap, the FFCRA requirements. I'm kind of going to go through 5 different chunks of the FFCRA so I can give you a working knowledge of how it works. First, I'm going to talk about coverage, which employers have to provide this leave. Second, I'm going to talk about employee eligibility, so which employees have to be provided the leave. So how do employees become eligible for the leave? Third, I'm going to talk about the reasons why employees take leave. So there's 6 specific reasons that employees can take leave under the FFCRA. Then I'm going to talk about how much leave employees are entitled to under the FFCRA. And then finally, I'm going to talk about how much employees are to be paid when they take the leave. So those are the areas we get like 99.9% of the questions. So that's a good working knowledge of how this works. So let's talk about coverage first. Let's talk about which employers are subject to the FFCRA. And it helps to look at employers in 2 different buckets. There's the private sector employers, and then there's the public sector or public agency employers. So private first. So as you can see on the screen, all private sector employers with fewer than 500 employees, including nonprofits, are going to be covered by the FFCRA. Public agencies, on the other hand, all public agency, that's all levels too, local, state, federal, they're going to be covered regardless of the number of employees they employ. So whether it's 5 or 5,000, they're going to be covered by the FFCRA regardless. So private sector, fewer than 500, public sector, regardless of the number of employees. And as you can see on that first bullet, that fewer than 500 count is a nationwide count, not an establishment count, but a nationwide count. So a McDonald's, a Target, a Kohl's, a Walgreens, obviously corporate owned stores in that family are not going to be covered because there's clearly more than 500 employees nationwide. But the count also includes full and part-time employees. Employees who might be on leave are counted, temp workers, day laborers, and then that last bullet says the count is made when the employee initiates the leave. So for employees who work for employers who are right around that threshold 500 mark, that count is made when the employee comes in and asks for the leave. Again, this is a nationwide count, private employers, fewer than 500 employees. Right now, I think I should highlight something that's very important because as employers, employees still try to digest this law. There's a lot of reasons why employees take leave these days that are related to COVID-19. But it's important for workers and employers to understand that there's only 6 reasons and only 6 reasons that qualify an employee to take FFCRA leave. So if for anything else other than what I'm about to cover, it might be leave, but it's not FFCRA leave. And so here are the reasons. Reasons 1 through 3. The employee is subject to, I'm reading right from the screen too. The employee is subject to federal, state, or local quarantine isolation orders related to COVID-19. Second reason, the employee has been advised by a healthcare provider to self-quarantine related to COVID-19. And reason number 3, the employee is experiencing COVID-19 symptoms and he or she is seeking a medical diagnosis. So just to highlight that third reason, that's a 2-part reason, that's a 2-parter. So the employee is experiencing COVID-19 symptoms, shortness of breath, dry cough, fever, etc. And he or she is seeking a medical diagnosis. So the employee can't make a unilateral decision, even if they are experiencing these types of symptoms. They just can't make a unilateral decision to stay at home and request FFCRA leave. They also have to be seeking a medical diagnosis, whether that's an appointment with a doctor or a test, something along those lines. So those are reasons 1 through 3. Reasons 4, 5, and 6. Fourth reason, the employee is caring for an individual who is subject to a federal, state, or local quarantine or isolation order related to COVID-19, or the employee is taking care of someone who's been advised by a healthcare provider to self-quarantine. Reason number 5, which is a reason that a lot of working parents take FFCRA leave. The employee is caring for his or her child whose school or place of care is closed or the child care provider is unavailable due to COVID-19 related reasons. And reason number 6, the employee is experiencing any other substantially similar conditions specified in the Department of HHS. So today, as we sit here, Reason number 6, no one should be taking reason under number 6 because HHS has not identified any substantially similar condition. So theoretically, that's off the table right now unless and until HHS identifies such a condition. But I'm going to go back to reason number 5 real quick. The employee is caring for his or her child, etc. There are a lot of different reopening models that school districts have, whether it's all in person or all virtual, distance, or a combination, what they call a hybrid. So I just want to draw your attention, and these are links that I'll provide Kelly when I provide the PowerPoint presentation. But one of those links that you're going to get is a link to the FFCRA frequently asked questions document. And there's about 103 questions in there and answers in there. If you look at questions 98, 99, and 100, and you can mark that down, just make a note of that. Those 3 questions directly address these different type of hybrid models we're seeing and whether or not working parents can take FFCRA leave depending on the school opening remodel. So there's a lot of different ones, combinations. I just want to make clear that there's an answer for whether or not employers have to provide the leave under reason number 5 based on that reopening model. Questions 98, 99, and 100 at FAQs document. Okay, so now those are the only 6 reasons employees can take leave under FFCRA. That's it. So any other COVID-19 related reason that doesn't fall into one of those 6 categories is not FFCRA leave. Okay. So the general rule is that every eligible employee, and I'll talk about eligibility in a second, that works for a covered employer, and we talked about private and public sector employers, is entitled to this leave. So they must be given this leave. There's 2 exceptions to that rule. There's a small business exemption, and then there's the healthcare provider / emergency responder exception. I want to talk about those 2 big exceptions to the general rule that all eligible employees get this leave. So let's talk about the small business exemption first. The small business exemption is like a 3-pronged test. Okay, so let's walk through this and see how it works. First prong, small business, right from the screen, the slide. Small businesses with fewer than 50 employees. So right off the bat, if an employer wants to claim this small business exemption, he or she must be a business owner with fewer than 50 employees. So that's a nationwide count. So if an employer has 50 or more employees, then this small business exemption simply isn't an option. But just say the business does have fewer than 50. What's the second prong? The second prong is the small business exemption can be asserted by the employer. And by the way, this is a employee by employee exemption. So it's not like a blanket exemption that, you know, I'm a small business, I'm asserting my small business exemption and no employee is going to be able to take leave. It doesn't work like that. It's an employee by employee assertion or exemption. And it can only be in response to an employee asking leave for one of those 6 reasons, which is reason number 5. The employee's leave is to care for his or her child whose school or place of care is closed or child care provider is unavailable. So if the employee is requesting FFCRA for any of the other 5 reasons under the FFCRA, the employer cannot claim this exemption. It's only in response to an employee who's asking leave for this specific FFCRA qualifying reason. Third prong, requirements of the FFCRA jeopardize the business viability. So let's walk through this and I'll show you exactly how it works. Dave Scoville he doesn't work for the state anymore. He was fired yesterday. Now he works for a smaller business that let's say, ABC pencil makers. That's who David works for now. Why he took that job, I don't know, but that's who he works for now. He goes up to his business owner and says, I need to take leave because my kid's school is closed. So bullet number 2 is met. He's talking to an employer who has less than 50 employees. Bullet number 1 is met. The employer can respond by saying, sorry, David, I can't give you the leave because your absence would jeopardize our business viability. So that's how it works. That's fewer than 50 employer saying to an employee requesting leave for this reason, I can't give you the leave because your absence would jeopardize the business viability. So the only question is, what does this jeopardize the business viability mean? Okay. So that bold language there on the slide, no application process language. Just want to make a point about that. I said earlier, this is an employee by employee exemption, and this is an exemption the employer doesn't have to send paperwork in. So there's nothing they have to certify or apply for or send anything to the DOL. They simply document, in this case, David, why David fits into one of these three categories. So those three bullets you see on the screen, David or anyone requesting leave for that reason would have to fit in one, not all three, but just one of these three bullet reasons. So let's say, for example, Dave fits into the first bullet. Dave's absence would result, and I'm reading right from the slide, Dave's absence would result in expenses and financial obligations exceeding available business revenues, etc. So the employer, she documents why David fits into that category and keeps that documentation on file in case the DOL inquires. So Mike might come along a month later requesting leave for that same reason. The school is closed, or the child care provider is unavailable, and Mike might fit into bullet number 3, insufficient employees. In Mike's absence, there are insufficient employees able, willing, and qualified in time and place needed to perform labor or services, etc. So document, don't send anything in, employee by employee exemption, and keep that documentation on file as to why they fit one of these 3 bullets. So that's the small business exemption and how it works. The other exception to the big rule that everyone's entitled to the leave is the employer, the healthcare provider / emergency responder exemption. The first thing off the bat I want to highlight on this exemption is that while the small business exemption can be asserted in response to only reason number 5, school closed, child care provider unavailable, the healthcare provider / emergency responder exemption can be in response to an employee asking leave for any of those FLCRA reasons. So that's a big difference. So they can, for any of those other 6 reasons that I talked about earlier, the employer's response can be, I'm going to deny you the leave because you fit into the category of a healthcare provider or emergency responder. So the only question for this exemption is, what does a healthcare provider mean and what does an emergency responder mean? So I'm going to draw your attention to that FAQs document again, because the healthcare provider definition has changed. So there was a court case that some of you probably heard about that the state of New York filed suit against DOL for some of the provisions in the FLCRA. There was 4 issues in this court case, 4 issues that were in play in this court case. And a couple of weeks ago, the DOL issued a response or clarifying guidance related to those 4 issues. And one of those 4 issues was the definition of a healthcare provider. And in the state of New York, so I think in their opinion, maybe the definition was a little too broad. So we have a new definition of what a healthcare provider is for purposes of this exclusion or this exemption. As you can see on the screen, that FAQs document, question number 56, goes into details of the new definition of a healthcare provider under the FLCRA. So make sure if healthcare providers are in your life or in your office or in your facility, and there's a possibility that you might deny the exemption based on this healthcare provider category, make sure you read the definition of a healthcare provider and make sure you get it right, because it's no longer what you see on the screen. It's what you see under FAQ item number 56. That's healthcare provider. The other side of that slash is emergency responder. And we're all kind of familiar with first responders and those type of jobs. So this language is right out of the regulations. So you can, Part 80, Title 29, Part 826 are the FLCRA regulations. If you want to Google or go there, you'll see this language as it is. But I'm not going to go through the language, but most of us are familiar with a lot of these job titles and job categories. So they too, in addition to the healthcare providers, they too can be denied the leave for any of the FLCRA reasons. So to recap, every eligible employee, we'll talk about eligibility in a second, that works for a covered employer is entitled to this leave unless they're being denied the leave based on the small business exemption or that healthcare provider / emergency responder exception. Posters. So most laws on all levels of government have some type of poster requirement that goes along with them, and FLCRA is no different. But there's two differences in the poster requirement for the FFCRA that aren't necessarily attached to other laws. The first thing is the language requirement, so that second bullet. So a lot of poster requirements for different laws require that if you have a workforce that's a substantial number of your workers speak English as a second language, for example, Spanish speaking employees, then there's a requirement that a Spanish language poster be available at the workplace. Under the FFCRA, the only required poster is the English version. We do have, I think we're up to 11 different language versions now, and they're optional, because the only one that's actually required is the English version. The first bullet, in the times we live in now, where a lot of employees are working remote or working teleworking or working away from the establishment or the shop or the office, the employer can meet this poster requirement or satisfy this poster requirement by either sending the poster by email, maybe posting the FFCRA poster on the internal employer's website, and then making sure employees can go there and take a look at it, sending the poster by regular mail. So there's a workaround, there's a way to satisfy the requirement if employees are not coming to the shop or coming to the office like they normally would. That's posters. Layoffs. So the month of April and even into the month of May, we got a ton of questions related to all these types of events and what happens when they occur with respect to FFCRA leave rights. So let's go through the ones we got the most, and I'll tell you how the law works. So first bullet, FFCRA requirements are not applicable prior to April 1st. So any leave employees would have taken before April 1st, even if now it would be qualified as FFCRA leave, then it's inapplicable. The law is inapplicable to those days or those hours of leave. Second bullet, if a business closes after April 1st, but before an employee takes leave, FFCRA requirements do not apply except to the days from April 1st to the date employees are laid off. So anything that happens before April 1st, we already know that doesn't count. What this bullet is saying is once a layoff occurs, then the employee rights to FFCRA leave cease. And the reason why is because now the layoff becomes the reason why they're unable to work, not one of those 6 FFCRA reasons. So that's a big event. If they're laid off, and this was happening a lot at the time when this first came out. Once they're laid off, even if they were on FFCRA leave, that event, that layoff, means their FFCRA leave rights end. Same thing with the third bullet. If the business is open but lays off part of its workforce, employees who are laid off or furloughed are not entitled to FFCRA. So a layoff, a furlough, a business closing, those events, when they happen, means the employee's FFCRA leave rights end at that moment, even if they were on FFCRA. So these are big events and they have an impact on the employee's entitlement. So up until now, I've been handling the FFCRA as a whole. It's this umbrella. I'm going to divide the FFCRA into the Emergency Paid Sick Leave Act, which I'm going to talk about right now. And then the second component is the expanded FMLA leave. The reason why I'm dividing them out, and they're all under the FFCRA leave requirement umbrella, but there are 2 separate leave acts and they operate a little differently and there are differences. So I want to point those out. EPSLA first. Big characteristic of the EPSLA is that first bullet. So an employee under the FFCRA umbrella, they can take leave connected to the EPSLA for any of the 6 qualifying reasons that I talked about earlier. So any of those 6 reasons. Second bullet, during leave, the continuation of health insurance. So if you're familiar with the old FMLA, the traditional FMLA, that continuation of health insurance is the same as it is in FMLA. It has to keep going through the leave. And the third bullet is the other big difference, or the big characteristic, I'll say, of the EPSLA leave. The entitlement to paid sick leave over a 2-week period. Full-time employees based on their schedule up to 80 hours, part-time employees based on their schedule, whatever that might be. So what that's saying is the amount of leave is 2 weeks worth up to 80 hours. That's the cap. So for example, if the employee is a 40-hour-a-week worker, they get 80 hours of EPSLA. If they work 35 hours per week, that's 70 hours of EPSLA total. Now, if they work 45 hours a week, they don't get 90 hours because of the 80-hour cap. Part-time employees, again, 35 times 2 is an example, but sometimes, a lot of times, part-time employees' hours may fluctuate or they may vary from week to week. Back to the FAQs document, I want to give you the answer to this one. Let's say you do have an employee whose schedule does fluctuate from week to week, whether they're full or part-time. Questions 80 through 85 walk you through the formula that employers are to use to come up with an average number of hours worked per week to use for the EPSLA leave. So it's based on a 6-month sample period, but that document it's fairly simple too, walks the employers through the formula to use if you do have employees whose hours fluctuate or vary. Eligibility I haven't talked about. So which employees can take EPSLA leave? That first bullet pretty much sums it up. It's pretty straightforward too. All employees who work for covered employers are eligible, period. So there's no minimum number of hours that have to be worked. There's no minimum number of days they had to be on the payroll, number of hours over 30. None of that applies under the EPSLA. So theoretically, if they were hired this morning, they can request EPSLA leave right now. So all they have to do is be working for the employer. And again, the second part of that slide is a reminder of what a covered employer looks like. So very practically everyone that's on the payroll is going to be entitled to the EPSLA leave, eligibility wise. Here's a reminder how much they get. Full-time employees up to 80, part-time times 2, or if it fluctuates, see questions 80 through 85 FAQ document. So what I have not talked about yet is how much your employees entitled to be paid per leave hour. So let me cover that right now. So as an employer or an employee, you want to keep track of this. To make the determination of how much the employees are entitled to per leave hour, the first thing you have to do is grab all the rates that are relevant, and then you're going to pick the highest rate and use that to pay the leave. So which rates are relevant? As you can see on the screen, the employee's regular rate of pay, the FLSA minimum wage, the highest applicable state or local or municipal minimum wage. So let's use a real world example and I'll show you how this works. So let's say the employee's regular rate of pay, in other words, they've been paid an hourly rate over the last 2 years of $15 an hour. That's their regular rate of pay for purposes of the FFCRA. So that's the first rate that's going to be on your radar. The second rate that's going to be on your radar is the federal minimum wage, which is $7.25 an hour. Third rate, down to that last dash, third rate, the applicable state rate. So for large employers, in my example, we'll use a large employer per the state requirement, $10 an hour, right? And so let's just add another rate in there just to make sure you know how this works. Let's say the employer is subject to the large employer hourly requirement under Minneapolis minimum wage ordinance, which today is $13.25. So that's 4 rates that this employer, in my example, has to have on his or her radar. The employee's regular rate, which is $15 an hour, $7.25 minimum wage federal, state rate $10, municipal rate $13.25. Obviously, the employee's regular rate of pay is the highest. It's $15 an hour. So the employer is going to pluck that one out. That's the highest. So what does he or she do with that rate? What the employee does with that rate depends on what reason the employee is taking leave. If the employee is taking leave for reasons 1, 2, or 3, and there's a reminder of what those are on the screen, then the employee is entitled to be paid 100% of that regular rate per leave hour. So in my example, they get $15 an hour per leave hour because they're taking leave for reason 1, 2, or 3. And there's a cap of 511 a day and 5110 in a 2-week time period. And that's way up there. So practically all employees are going to fall under that cap. $15 though was the highest rate. That's where we started. Let's say they're taking leave for reasons 4, 5, and 6. And there's a reminder of what those reasons are on the screen. For those leave reasons, the employee is only entitled to be paid 2/3 of that regular rate. So in my example, that'd be $10 because $10 is 2/3 of 15. So because they're taking leave for reason 4 or 5 or 6, they don't get 100% of that rate. They only get 2/3 of that rate. So whatever the leave reason the employee is taking or using the leave for determines how much they're paid per leave hour. And there's a cap of $200 a day and $2,000 in that 2-week time period for those employees taking leave for one of those 2/3 reasons, what I call them. Let's set aside the EPSLA and bring in the expanded FMLA. Again, these are two components under the FFCRA umbrella. Big difference, bullet number 1, between the expanded FMLA and the EPSLA. While employee can take leave for any of the 6 reasons under EPSLA, under expanded FMLA, they can only take leave for only one reason. It's good old reason number 5, to care for his or her son or daughter whose school or place of care is closed or the child care provider is unavailable. So if an employee is taking leave for any of those other 5 reasons, it's not under expanded FMLA, it's going to have to be under the EPSLA. First big characteristic difference. The second bullet is the second big characteristic difference between the expanded FMLA and the EPSLA, the amount of leave. Remember, EPSLA is 2 weeks, 80 hours cap. Under expanded FMLA, up to 12 work weeks of job protected leave. So more leave, but for only one reason. The third bullet, initial 2 weeks are unpaid. And put an asterisk by that, because I'm going to say there's 2 options the employee can exercise to turn that unpaid period into a paid period. But the way the law is written, the initial 2 weeks are unpaid. But regardless of what they do in those initial 2 weeks, the remaining 10 weeks they're allowed to be paid 2/3. Again, and the reason why it's 2/3 because it's reason 4, 5, and 6. 2/3 of that regular rate per leave hour. I haven't talked yet about the employee eligibility for expanded FMLA. Remember, eligibility for EPSLA leave, just be on the payroll. Different with the expanded FMLA. So that first, the top of the slide, all employees, including full and part-time employees of covered employers, are eligible for the expanded FMLA if they have been employed by their employer for at least 30 calendar days. So that's 30 calendar days prior to the date the leave is to start. So it's a big difference between the eligibility requirement under the EPSLA and expanded FMLA. And as a reminder, what a private sector employer looks like and what a public sector employer looks like. So again, EPSLA, less leave for any reason. Expanded FMLA, one reason only, more leave. Earlier, a couple slides ago, I said put an asterisk by that 2-week unpaid period under the expanded FMLA. Here's the options the employee can exercise to turn that unpaid period into a paid period. I'm on that first dash. Option number 1, the employee may choose to use paid sick leave under the EPSLA. So they can slide that 2 weeks worth of EPSLA leave and plug it into what was otherwise an unpaid period and turn it into a paid period. It's option number 1. By the way, these are employee options, not employer options. The employee holds the cards as far as whether or not they want to exercise these options. Second option, the employee can use accrued paid time off under the employer's benefit package or the employee's leave program. So any PTO accrued by the employee working for the employer per the employer's package, they can also slide that in and turn that unpaid period into a paid period. But again, those are employee options to exercise or not. The second bullet, regardless of what they do for the remaining 10 weeks, they're paid 2/3 of their regular rate, and there's a cap during those 10 weeks of $200 a day and $10,000 for the 10-week time period. Okay. One point I want to make about FMLA, traditional FMLA and expanded FMLA, combined, employees are only entitled to 12 weeks. So let's say before this law was enacted, or I should say before this law became effective April 1st, let's say in January, an employee took leave because she had a child and she wanted to use 12 weeks of FMLA as bonding period under the old FMLA from January 1st to April 1st. By the time this law became effective on April 1st, she had no more leave to use under the expanded FMLA because under the expanded FMLA and FMLA combined 12 weeks and 12 weeks only. Now she would have 80 hours to still use under the EPSLA because that's unaffected by what she used under traditional FMLA. But as far as expanded FMLA, she would have exhausted all of her leave. And finally, this is our resource page. Again, you're going to have this PowerPoint. And so the third bullet down is the Families First Coronavirus Response Act Q&A document. That's the one that has the due definition of healthcare provider. It has those Q&As about school opening remodels, and it has most of the questions you probably are going to have, as long as they're not like, some of these, we get these questions that kind of get down into the really weeds of it. But generally, questions that you'll have are probably going to be answered on that document. So I encourage everyone to take a look at that if a question pops up. Okay, I wanted to leave a little time for Q&A, so I hope I did, and I'll stop sharing my screen too.
Actually, if you want to just leave it up, Corey, that'd be fine.
Okay.
We actually had a bunch of questions come in from your presentation. David went through and answered all his on his own, so he was a little ahead of the game.
He always is.
So, if someone in an employee's household is getting tested for COVID, is an employee entitled to FFCRA until results come back? MDH indicates they should both stay home in this situation.
Yeah, so if they've been advised by, under reason number 1, if a government agency has instructed them to quarantine, that's going to fall under reason number 1. That's good enough. That's a reason all by itself. There's also the other reasons where reason number 2, 3, when they have symptoms and they're actively seeking a medical diagnosis, that's a reason it could fall under, because actively seeking a medical diagnosis includes waiting for a test. So it could also fit into that category. But I would say if they were advised to self-quarantine by the Department of Health, I think that's who would do it, I'm not sure, but that's a government entity that falls in a category number 1. So that would be end of the story as far as reason number 1 is concerned.
Okay. Another question was, can a person take EPSL at more than one employer, or is it 80 hours total for a full-time employee?
Yeah, it goes with the employee. So they don't get to jump employers and get a fresh 80 hours. It goes, the employees get this total during the leave year. So
Okay.
they don't, in other words, you work for 2 employers, you don't get 2 sets of FFCRA leave. I also want to add something to the previous answer that I gave as far as the self-quarantine. Keep in mind, for any of these 6 reasons, they have to be the reason that employees are unable to work. So let's say, for example, you are self-quarantined, but you're able to telework and the employer still has work for you, and you guys can work out a schedule where you can still get your work done. So the reason for the leave has to be an impediment to working. It's not good enough that they were self-quarantined if they can continue to put in 8 hours a day teleworking. I just want to make that point.
Right. So I guess my question would be, how would you know, or how is that tracked then, whether or not somebody's taken EPSL from 2 different employers?
Each employer is responsible for tracking the leave. Oh, you mean how would both of the employers together track whether or not this person has taken more leave than they're supposed to take?
Right.
The regulations don't talk about that, to be honest.
Okay, I'm just curious.
Yeah, the regulations don't talk about that. But I mean, in reality, this is being recorded, so I'll just stay right there. I won't go any further.
Okay.
Yeah,
I would assume that there's ways later on down the line that would get caught, but isn't this, so then one of the employers wants to know, isn't this the same pool for FFCR if they already exhausted their time for COVID related illnesses? Are there still 80 hours for EPSLA?
So I'm not really understanding the question, but if they're asking if can they use FFCRA for different reasons throughout the leave year, you think maybe that's what they're asking? So, for example, they need from reason number 1 now, and then a month from now they may need it for reason number 5. Is that what you think they're asking?
I'm wondering if they're thinking FFCRA and EPSLA.
Yeah, so FFCRA is the umbrella. Yeah, they're the umbrella, and underneath that umbrella, they get up to 12 work weeks of leave. And depending on the reason they need to leave, it falls under the EPSLA or the expanded FMLA.
Gotcha.
Yeah, it's a little, you got to kind of think about it for a second to make it to make sense.
One of our other employers says, I have an employee who says he needs to provide childcare and schooling for his child on Fridays. Which do I use, EPSL or FFCRA?
Well, it's going to be, they're available for both. So, so if you take let's say, for example, you take the 2 weeks of the EPSLA leave, and then you run out, but you still need leave for reason number 5, you'll have that expanded FMLA for additional 10 weeks. So you don't get 2 plus 12, you'll get 2 and then an additional 10 weeks because you get up to 12 weeks total. So there's 12 weeks in that bank for that reason if you qualify for both leaves. And how you use them, I guess, will depend on how much leave you need throughout the school year.
Okay. There's an EFMLA. What is I think what they're questioning is, what does the E stand for?
Expanded.
Expanded. All right.
Yeah. Expanded Family Medical Leave. No, I'm sorry. Emergency Family Medical Leave Expansion Act. So that E is emergency.
Emergency. All right. It's a lot of letters. We like alphabet soup of the state and federal government, you guys. If you think you're confused, you should see our letters sometimes. FFCRA paid leave. I have an employee that had a COVID test done and showed me the results, which were negative. However, he did not provide me with a date in which the results were provided to him. My understanding is that they are paid the FFCR up until they receive their negative test results. Do I have to require that the employee provide me with a date that the test results were provided to him?
See, this is where it gets a little murky. Is a good word to use. The guidance, the FAQ guidance and the regulations talk about how far an employer can go with respect to what they can ask for. And date test result returned, it isn't in that language. However, employers, they have to deal in the real world. I understand that. My recommendation, this is a recommendation I give, and it might be, some people may not be very happy with it, but the recommendation I usually give, if that becomes an issue as far as trying to figure out what's going on with the employee, you're better off calling us and asking us, is it okay if I do this or request that? As opposed to just going and doing something that the regulations say or don't include is allowable for the employer, or information the employer can necessarily request per the regulation. So if there's something you need from the employee and the regulations don't allow, and the regulations are very clear on how far you can go, so is the guidance. If you feel like you're going to go exceed that guidance, I think you need to call us to make sure you're not violating the FFCRA.
Okay.
And yeah. Let me say this too, Kelly, about the first question. I think it was the first question. As far as the FFCRA and how it attaches to the employee versus attaching to where they work at and they go to another place. Let me send you some language on that. Okay. Let me look at a couple things and make sure I'm right on the button, because there is some language. I want to make sure I get it right. So everybody kind of put a bookmark in that question, and then Kelly should be able to provide you from me some additional guidance on that one question.
Okay.
Yeah.
One of our employers wants to know, can I require a new employee to test for COVID so as not to take on their FFCRA liability?
The FAQ documents talk about, I wish I knew what question it was. I'm pretty good at memorizing these question numbers, but there is some guidance in the FAQs about, there's a question specifically along these lines about what an employer can do to protect his or her workforce. And that sounds to me like the question that was just asked is along those lines. So
yeah, they're a healthcare provider or a current direct care provider, and they're protecting their staff. Obviously, they need people that are going to be there.
Yeah. Yep. The answer to the question I'm thinking about in the FAQs document, you should go there and read it. Don't rely on my faulty memory. But the question does allow, the answer does allow the employers to put certain safety safeguards in place, even though we do have this FFCRA thing. So I can't think of the question number, but it's in that document and it should address the specific question. But I just want you to know there is, in that answer, the DOL allows the employer to come up with certain safeguards to protect the health and safety of its workers, despite the requirements of the FFCRA. So you should check that out. I'm sure that'll answer the question, that item.
One of our employers is asking, can you move someone from EPSL to EFMLA if their school is sending their child home because their group at school had someone test positive? The school and MDH are requiring the child stay home for 14 days and be tested for COVID after they are home 5 days. Should we use EPSL for the 10 days and then do the FMLA, or for the 4 days once the 10 days of sick time is used?
Yeah, I would let the employee request leave, whether or not they're requesting EPSLA leave or expanded FMLA. If they don't identify which one they want to take the leave under, give us a call. Give our enforcement staff a call and see how they would treat that. Because that's a question that I don't get a lot, but I get it, because when employees ask for leave, they're just going to sometimes they just ask for leave. They don't ask for, oh, I want it under EPSLA, or I wanted it expanded FMLA. So I'm not totally familiar with how our enforcement staff would handle that situation. So I encourage you to give us a call, and I'll also include our 866 number. Okay. I thought it was on this, but it's not. But yeah, that's a good question. I understand how a lot of employers could run into that. So just give us a call. I want to make sure. I want the enforcement staff to weigh in on how they would see something like that.
So if a spouse of an employee is being tested but not the employee, does the employee qualify for FFCRA?
If he or she falls into one of those six buckets, 6 reasons that I talked about. So just the testing alone doesn't mean they're going to fall into an FFCRA reason. But if they were required to quarantine, or if they got symptoms and they were seeking a diagnosis, then they would fall into one of those 6 categories. The best thing to do is to look at the poster, just to remind yourselves of what these 6 reasons are, and whether or not the employee falls into one of those 6 reasons. Because a lot of times employers will see that it's COVID-19 related, so can they take FFCRA leave? The answer is no if it doesn't fall into one of those 6 categories. It didn't sound to me, based on the way that question was asked, that it triggers any of those 6 reasons yet. So, okay. Yeah.
All right. Well, we are at 1:05, you guys. I want to thank you for joining us today, and I want to thank David and Corey. Again, I have been recording the session. You will get a copy of the recording and of Corey and David's PowerPoints for today's session. I'll also be emailing out the link for tomorrow's session here, probably within the next hour or so. So I look forward to tomorrow's session as we learn about wage theft. That Absolutely. Should be an exciting session. That usually generates a lot of questions from everybody too. So thank you guys, and I will see you all tomorrow.
Thanks, Kelly. We'll send you that information too.
All right. Thanks, guys.